Hello and welcome to Free Speech Unmuted, a Hoover Institution podcast. I'm one of your hosts, Eugene Volokh, Senior Fellow of the Hoover Institution and Professor of Law Emeritus at UCLA Law School. And I'm joined by my other co-host, Jane Bambauer, who's a professor at the University of Florida, also a law professor. And today we're going to be talking about what's been much in the news, which is the president's executive orders targeting particular law firms for particular kinds of penalties, let's say loosely, based in part on their previous litigation positions and their previous advocacy. Those orders, some firms have worked out a deal with Trump to get these orders rescinded or prevented. Others have challenged these orders, and at least two have gotten temporary restraining orders against them. And the question is, what should we think about these orders? Are they in fact unconstitutional? Mostly we'll talk about the First Amendment issues, but there are also undeniable Fifth and Sixth Amendment issues here having to do with due process and right to counsel. So Jane, tell us a little bit more about the orders generally and kind of the big picture of how firms have reacted to them.
Yeah, over the last couple of weeks, President Trump has issued a few orders targeting. Each order targets a specific firm and describes the things that moved President Trump to want to put restrictions on the federal government's use of the firm, and then also restricting the firm's access to various things. So for example, in one of the very most recent executive orders, President Trump targeted a firm and explained that they have, represented partisan clients for partisan issues to achieve political ends. They've supported, that's sort of based on client representation and particular positions in cases. But then the executive order also explains that the law firm, quote, I'm quoting here, supports attacks against women and children based on a refusal to accept the biological reality of sex. So that might sound like it's more of just a, outward-facing public position that the firm has taken, maybe a purely expressive position. And then also, in some cases, some of the firms have been accused of hiring using race-based preferences and that sort of thing. So I raise this because it's sort of a mix of sins, according to President Trump, that each firm has committed. And then in response, President Trump has done a few things. First, has canceled and prohibited future contracts with those firms. So the firms that some firms are highly reliant on clients that are, part of the federal government. I think in one case, one of the firms involved, 30% of its revenues come from clients that are that are part of the federal government. So that's a big deal. The contracts are a big deal. Security clearances have been stripped to all lawyers of these firms, and so that it will be a very consequential, decision for the firms that tend to litigate things involving national security or criminal, or maybe even some criminal law. And then the executive orders also restrict the firms from accessing government buildings. And it's not quite clear exactly what the scope of that access restriction is. And that's something that I think has frustrated at least one of the judges said so in his opinion. So Eugene, you want to explain? So as you said, the firms have taken a mix of approaches, some working out a settlement, an agreement so that they don't lose access to these things. And of course, they've been under, the firms that have done that are coming under some criticism from the general public and maybe even from their clients too for what looks like caving too quickly. And other firms have actually brought constitutional challenges. So Eugene, do you want to explain how the constitutional challenges work and what's been happening so far?
Sure. So uh, there have been a couple of decisions in the challenges. Excuse me. There have been a couple of decisions as to the challenges that have been brought. The most detailed one was in a case involving the Wilmer Hale law firm. And by the way, these are just with regard to temporary restraining orders, which is why the decisions
Right.
came so quickly. And the interesting thing, among other things, one interesting thing about the Wilmer Hale case is the lawyer on that case is Paul Clement. Paul Clement was Solicitor General during for part of the Bush Jr. administration. He is very much a conservative. I know him personally, unlike him, but and I shouldn't say but. And I also know that he is personally quite conservative. And he's also just in general a very, very well regarded advocate. And he's actually spoken up for a lot of conservative causes. He's left a couple of firms when these firms apparently did not allow him to represent particular conservative positions that he wanted to represent. So he has real credibility, I think, both as a very well regarded advocate and as somebody who has personally fought for conservative causes in his saying, well, that this is an improper restriction on law firms as well. So what is the nature of his and his colleagues' argument? Well, part of it is that the First Amendment protects, through its free speech clause and through its petition clause, protects the right to take a wide range of litigation positions, both as a client and as a law firm. And if the courts ultimately reject those positions, then you lose the case. But you haven't done anything illegal in making those arguments, and you've done something that's protected by the First Amendment that the government should not retaliate against you for. So just to give a few examples, the executive order about Wilmer Hale says, Wilmer Hale engages in obvious partisan representations to achieve political ends. Well, of course, that's what a lot of law firms do, and that's what they're entitled to do, just like politicians are allowed to propose politically laden statutes and government actions to achieve political ends. Just as citizens are entitled to make political arguments to achieve political ends, law firms are entitled to engage in partisan representations to achieve political ends. Likewise, supports efforts to discriminate on the basis of race. If it discriminates based on race, it can be sued for that. Actually, separately, the order also separately, the government has also criticized these firms for actually engaging in race discrimination, and that's something that could be a basis for both lawsuits and various kinds of executive branch action. But simply supporting efforts to discriminate based on the basis of race, people are free to do that. You can support efforts to discriminate against whites, against blacks. This is supporting efforts to do something in this context simply means advocating, simply means speaking, or again, filing lawsuits. Likewise, backs the obstruction of efforts to prevent illegal aliens from committing horrific crimes and trafficking deadly drugs within our borders. To be sure, if it backed the obstruction of those efforts by giving money to people, I don't know, who would attack police officers who are trying to arrest someone, or ICE agents or whatever, that might be criminal. But that's not the way that they are backing the obstruction. They're backing the obstruction of such efforts by litigating with regard to that. That is something that the First Amendment protects. Now, the orders in this case were focused on the First Amendment, but the lawsuit brought by Wilmer Hale, and I think some of the other lawsuits as well, are also talking about two other amendments. Now, this is free speech unmuted, not due process unmuted, but it's worth keeping in mind, in part because the Bill of Rights and parts of the Constitution are connected, that restricting, essentially punishing law firms for, governments punishing law firms for advocating on behalf of crimes interferes with people's ability to get legal assistance, which is protected in criminal cases by the Sixth Amendment, and in most civil cases protected by the Fifth Amendment, the Due Process Clause. That if law firms know that advocating for a particular position is going to get them retaliated against by the federal government, there will be a lot fewer law firms who are willing to advocate for those positions, and clients will therefore will not be able to exercise the rights to get a lawyer. So those
Can
are
I,
the challenges that are currently before the court. I'll get to in a moment the short but somewhat detailed order that Judge Leon issued in this case. But first, Jane, looks
yeah,
like
I do. Yeah. So so you've characterized the retaliation based on the wide range of litigation positions or against filing of certain lawsuits as covered by the First Amendment and also due process and maybe Sixth Amendment as well. I would actually, there's some danger, I think, in suggesting that the actual act of litigating and anything that's filed formally with a court as part of litigation is covered by the First Amendment as opposed to these other constitutional rights. So for a minute, let me put aside, it's true, it's absolutely true that Trump in part, President Trump is in part retaliating against these firms for pure speech or advocacy to the public, like taking a position or a stand on whether it's affirmative action or trans rights or whatnot. That I think you and I would both agree that if they are being retaliated based on that, this is clearly covered by the First Amendment, and we would have that conversation. But suppose that President Trump was much narrower in his explanation, and it's really exclusively based on filings that these law firms have made in certain cases that he sees as, highly left-leaning or something like that. The danger, I think, in treating this as a First Amendment issue. So by the way, one initial question is when I see the discussion of this as a First Amendment issue, I usually see references to NAACP versus Button, and we can talk about that. But I'm wondering if there is any other precedent that maybe we should talk about as well. But the danger of treating this as a First Amendment issue is that when the way to understand why the complex rules involved in litigation do not violate free speech, and why we don't have to go through a First Amendment analysis every single time somebody is, for example, prevented from being a member of the bar, being an attorney, or anytime somebody can submit some evidence but not others. The reason we can just kind of sidestep the entire First Amendment analysis that would be quite tricky otherwise, in my mind, has always been that there are certain things that, yes, are accomplished through speech, but they are acts or transactions. And the means and the reason we regulate them is because of the act or transactional nature of it. And lawsuits and litigation is one such thing. This is what helps, I think, keep otherwise capacious understandings of the right to free speech, which I tend to hold, safe from claims by, like, for example, Robert Post and others who say, taking the position that speech is speech is speech is speech is speech is ridiculous. Because if you really think all speech is speech, then we wind up in these kind of absurdities where we're having to ask whether the rules of evidence are constitutional, for example. So I don't know. I for the sake of free speech, I actually prefer having a clean boundary, and the boundary begins or ends, however you want to look at it, when the filings, where the filings begin. Curious what you think of that, both as a policy matter, but maybe more importantly, whether the case law has clearly said something on this matter.
Well, so first, let me just highlight, I think, an important point that you're making, which is that in court and in court filings, free speech rights, to the extent that they exist, are extraordinarily limited. One thing that you learn is it's not only a foolish idea to insult the judge, let's say, or even insult opposing counsel, in that it could be foolish because if you insult the judge being human is more likely to rule against you, but it's also potentially sanctionable.
Right.
You could get fined. You could ultimately get disbarred if there's a pattern of such rude behavior. Partly because, as a practical matter, if you want to have the legal process be effective in settling disputes, people have to be civil to each other. Otherwise, incivility will just undermine the process, make it much harder to reach settlement and the like. Likewise, the rules of evidence are speech restrictions in the courtroom, right?
Right.
The judge may say, you're not allowed to argue to the jury the following things because they're hearsay or because they're privileged or whatever else. So I totally appreciate that free speech in the courtroom is sharply limited. The same thing is true in filings. However, the First Amendment, and again, we're free speech unmuted, but that's shorthand for freedom of expression in various ways. The First Amendment protects not just freedom of speech, but the freedom to petition the government for redress of grievances. And the
Hmm.
court has
Petition clause, so often ignored.
so often ignored. The court has recognized in a variety of cases that filing lawsuits is exercise of petition clause rights. Just to give an example, there's a line of cases that make clear that lobbying the legislature for anti-competitive laws doesn't violate antitrust law. It may be successful in limiting competition, but everybody has a right to limit competition by arguing to the legislature. Maybe it violates antitrust law to limit competition by entering into cartel agreements or whatever else. But if you're limiting competition by uh, um, uh, 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 asking the legislature to do something, that's generally speaking constitutionally protected. I oversimplify here, but basically that's so. Well, what happens if you try to limit competition by suing your competitors? And the general answer is so long as the lawsuit is not frivolous or based on kind of factual misstatements, generally speaking, that too is protected because the petition clause includes your right to petition the courts for redress of grievances as well. And I think cases like NAACP Button and other such cases also reinforce that. So it's quite clear that at least the client, if a client hires a law firm to go to court, they can't then be punished for just going to court unless they violate in the process some existing rules, like
Right.
filing a
Right.
frivolous claim, not just a losing claim, but a frivolous claim, or
Yep.
like, for example, lying to the court or something along those lines. And I do
Okay. And
think
so
that
to
the cases
protect to protect the client, then you need to protect the law firm
right.
because how can
Now,
they
the
be
law
represented? Yeah.
firm may have its own petition clause, right? Because it might say, we're filing the petition. We're actually signing the petition. To be sure, it's as agents of the clients. And some of the time we stress we don't necessarily agree with the client, but some of the time we do agree with the client. So maybe it has its own petition clause rights. Maybe you might say it's a freedom of association claim that in order for the client's petition clause rights to be vindicated, he needs to be able, I say he, often it's it, either the business or the individual needs to be able to associate with a lawyer. In fact, for businesses aren't allowed to even file pro se, so they have to by law hire a lawyer to do that. So therefore, that petition clause has to protect the lawyer for retaliation as well. Otherwise, that interferes with the client's rights. So one way or the other, I think that the First Amendment, and in particular, you might say the free speech clause, you might say the petition clause, you might say both plus implicit right of association, which has been recognized as the free speech clause, I think applies equally to the petition clause, does indeed protect these law firms' decisions. Doesn't protect them from penalties for violating particular ethical rules. Again, if they lie to the court in the process, of course they can be punished. Or again, if they violate the rules of evidence and do other such things. But the actual filing and litigating within the rules of the lawsuits is, I think, protected by the First Amendment.
Yeah. Okay. It's funny though that it just as a as a pure matter of theory, it still sort of bothers me, I have to say. To me, the filing of the suit is more like the legislative act than it is like the lobbying of a legislator to get something
Mm,
done. And if we don't, if we treat it more like lobbying, then that opens up to me at least the next question, which is Why should you have to be a member of the bar
Oh,
to represent a client and to file a lawsuit?
that's a
If there's
great question,
yeah,
which other
okay.
people have raised.
Which they've
And
raised, yes.
in this whole
And
professional
I've
client
yeah,
speech debate, which I think we haven't talked about, but is actually now
not
going to be
much.
before the Supreme Court, and I want to say Childs v. Salazar, the implicit in that is the question like, can you require, isn't it a prior restraint on speech and petition to require lawyers to be members of the bar? Uh, or for
Yeah.
that matter, to require psychiatrists who want to deliver the talking cure to be licensed as psychiatrists. So that's an
Mm.
interesting, I think, and a very important question. And again, I think one important point you're getting at is that unlike most speech or unlike lobbying, filing a lawsuit actually does have direct legal effects.
Exactly.
If I
Yeah.
sue
This
you, not that I ever would, but if I sue you, then
bring it on.
then
Just kidding.
you have to file an answer or a motion to dismiss and probably pay money to hire a lawyer to do that. If you're a corporation, you absolutely have to hire a lawyer because corporations can't represent themselves. If you fail to do that, then I can get a default judgment and you have to pay me money. Generally, if I
Yeah.
just say things to you or say things about you, that doesn't have the same kind of legal effect. And that's why the rules under the petition clause as to litigation are not identical to those as to lobbying or as to public
Mm.
advocacy campaigns. You
Okay.
do have to comply with various legal rules. You can't file a lawsuit that is frivolous. You can make public. There's no, at least I think you can't be sanctioned for making a frivolous argument on a podcast, right? I don't think you can be sanctioned for
God
making.
forbid.
Pardon? Yeah, exactly. That yes, that would be very bad.
Yes.
I don't think you can be sanctioned for making a frivolous argument in a letter to a legislator. You might be sanctioned if you actually defame someone for that, but bracketing that, if you
Yeah,
make
true.
a frivolous argument there, I don't think you can. You can be sanctioned if you testify falsely, but if you're just making a silly argument that's inconsistent with the existing law, you can't be sanctioned. In lobbying, you can be in the litigation process. So I totally appreciate they're not
Yeah.
identical. But the cover, that is to say, the coverage of the petition clause as to litigation and as to lobbying are not identical with each other, and they're not identical with the free speech clause as it covers public advocacy. But I do think they provide a lot of protection here, and I think that
Okay.
here the
Well,
president.
I just want to be on record that I actually think that's wrong as a matter of policy. And
All
I
right.
think it's distinguishable from NAACP versus Button. So just to catch the audience up on that
Yes.
case, that case involved a state law that was going after what was characterized at least as improper solicitation of legal services or legal business, and targeting. Clearly, it was motivated to target the NAACP, which was holding kind of public sessions where they describe how the civil rights could be enforced or litigated through impact litigation, and then would try to convince some of the members of the audience to go ahead and bring impact litigation. And there the Supreme Court said that the law limiting legal services solicitation was unconstitutional. But that to me still, that's still prior to the filing of the suit. And as you say, Eugene, when a suit is filed, the lawyer is acting as an agent of the judiciary as well. Of course, they are a representative, but and with that comes, you're right, the obligation of the other side to respond or else. And so anyway, so maybe there's some I don't know, there's some reason to at least debate whether the First Amendment coverage question has been decided correctly.
Well, for podcast purposes, that's all the better.
Yes.
But so let's look at what Judge Leon, federal district court judge in D.C., said in his order granting a temporary restraining order. So this is very early in the litigation process. So unsurprisingly, the judge's opinion was quite short. Sometimes these TROs, as in, for example, the Jenner and Block case, another judge issued just a TRO that just temporary restraining order that just indicated what the order was ordering and didn't even give much of an explanation. But Judge Leon offered a little bit of an explanation. It's worth focusing on. So first he says the First Amendment prohibits government officials from subjecting individuals to retaliatory actions for having engaged in protected speech. That's an important point. I think it's very well settled, but it's important to recognize it's not like President Trump is saying in his executive order, these lawyers are going to jail, or even these law firms are being fined, or even these law firms are being disbarred, so it shall be illegal for, I shouldn't say law firms, lawyers of these firms are being disbarred, so it shall be illegal for them to practice law. He's essentially saying the government isn't going to deal with essentially deal with clients of those firms. So Section 3 says of the executive order talks about that the federal agencies shall terminate any contract to the maximum extent permitted by applicable law for which WilmerHale has been hired to perform any service. And it requires that government contractors disclose business they do with WilmerHale. So it's targeting government contractors' employment of WilmerHale for various kinds of deals they're trying to do with the government. That the judge says that is impermissible retaliation based on WilmerHale's exercise of First Amendment rights.
So they could cancel the contracts because they're too expensive or something. It's the wrong reason for canceling them.
Right, partly that, but also partly I think it isn't just focused on possible contracts between the government and WilmerHale. I don't know how often the federal government hires WilmerHale, among other things. They are very expensive, and the government has lots of its own lawyers. It's also focusing on entities that do business with WilmerHale. Section 3B says heads of agencies shall review all contracts with WilmerHale or with entities that disclose doing business with WilmerHale. So the cancellation would be of contracts with, let's say, some company that produces military equipment, but that has hired WilmerHale for negotiating the deal, or even possibly for other deals. The other form of retaliation in Section 5, where 5A says that agency heads shall provide guidance limiting official access from federal government buildings to employees of WilmerHale when such access would threaten the national security of or otherwise be inconsistent with the interests of the United States. So it's not actually a prohibition on WilmerHale employees setting foot in federal buildings as such, but it does indeed sort of signal that there may very well be such prohibitions, and it orders agency heads to figure out if such prohibitions should be imposed because just based on this very vague standards of interests of the United States. So I've heard some say, oh, this order excludes WilmerHale from federal buildings, including courthouses. I don't think it does that by itself, and it may be that courthouses may actually be different. But what it does is it creates this risk, which signals to WilmerHale and to other law firms and the clients.
And the clients,
you know, if you, the client, hire WilmerHale, it may very well be that 2 months from now, they're not going to be allowed to set foot, even if not in a federal courthouse, but in the federal agency building where they're supposed to be negotiating the contract. And because that might happen 2 months from now, might not, but it might. Today, the client might say, well, how can I enter into a deal with you if I know you've got a target on your back? Because if you've got a target on your back, would be a target on my back, essentially, as a client as well. Interestingly, so I'd say Section 3 and 5. Section 1 is background. Section 4 deals with authorizing enforcement actions against alleged race or sex and other such discrimination, illegal discrimination in hiring and such by the firms. That's a separate matter. It has to do with claims which might be accurate by the government that the firms are engaged in impermissible race discrimination or affirmative action programs and such. Uh,
Mhm.
but uh, but that's not really much focused on here. Section 2 deals with security clearances, and it says that essentially the federal security establishment shall immediately take steps consistent with applicable law to suspend any active security clearances held by individuals at WilmerHale, pending a review of whether such clearances are consistent with the national interest. And that the judge did not block, in part because the law about security clearances is its own separate beast, which does indeed provide a very broad discretion to the executive branch. I
Mhm.
don't know much about the law. I just know enough about security clearance law to stress that the analysis, the First Amendment analysis, as to the government buildings, First Amendment analysis as to government contracts, may end up being quite different from that for security clearances, or perhaps vice versa. It may be there's very strong First Amendment protection against the other kinds of retaliation, but when it comes to security clearances, a lot harder to tell. So I just want to stress I'm not sure that the firms will ultimately lose as to security clearances. I do think that the arguments that the administration gives has a lot more to do with these are our political adversaries.
Right.
I don't
Yeah.
like what
That
they did
rather
to
than
me, Donald Trump,
right,
than to any
rather than
real
unsafe security. Yeah,
right,
I
than
agree.
to any real threat to national security. But courts are much more differential to executive branch judgments with regard to security clearances. Just to offer one particular example, again, I'm not even sure how it would come out, but let's let's look at First Amendment arguments in the security clearance context. If somebody says, I think Xi Jinping is a fabulous world leader because he is the head of the Communist Party, Chinese Communist Party, which is the guiding light for the world going forward. And all countries should do whatever all countries and all people within those countries should do whatever they can to advance the cause of communism as understood by the Chinese Communist Party. I should stress, very much not my view, but I will defend quite firmly the right of any person to articulate that
To
view
say that.
without being criminally punished or whatever else. Should this person get a security clearance? I'm pretty skeptical, at least,
Yeah.
because among other things, security clearance is based on judgment about how much you support the various activities of our government. And if you're sufficiently hostile to them or friendly to our opponents, maybe it might be permissible to just deny you the security clearance because of your viewpoint. So that suggests the First Amendment
Right.
analysis, even as well as what the First Amendment analysis wouldn't come out the same way. And of course, there are all sorts of statutory constraints on review of security clearances. Again, I think that on the facts of this case, I think the argument for denying the firm security clearances appears to be very, very weak as a practical national security matter. But what I just said is aimed to highlight that the analysis with security clearances may very well end up being very different in many ways than
Yeah, and that ideology really does play an appropriate role, or might at least play an appropriate
right,
role with security clearances, whereas it wouldn't, you know, whereas it would be
right,
more straight up
right.
retaliatory in the standard ways. And the okay, so now I understand a little better though the importance of the contract restriction, because this is not just a boycott of the firms; it's a secondary boycott. To go back to our
There you
the
go.
podcast we had on that topic, and so one thing I wanted to ask you was what you think the right, what you think firms are thinking in terms of their strategy here. Because on one hand, as you suggest, I think firms would be very worried about having clients who are not interested in getting involved in the mess. They don't fault the law firms or the lawyers necessarily, but they just don't want to take the time and resources to to stick with a firm that's going to have to go through the hassle. On the other hand, I could also imagine some clients engaging in a counter boycott. And so, I think in the Trump too, we are back to, I was hoping, I was hoping after the last few years that we could start separating business and politics a little bit more, but I don't, it doesn't look like that's in our near future, I'm afraid. So yeah, so what do you think law firms
Yeah.
are?
So at various times in my 30-year career, not a lot of times, but a few times, people have approached me and said, Wallach, we're doing a dean search for our law school. Would you like to be, or somebody suggested that we talk to you as a possible dean. And I don't think I laughed out loud. That would be rude, but I laughed on the inside. And the way they articulated it is that I am totally temperamentally unsuited to being a dean. I also don't have experience, in part because I'm temperamentally unsuited to being an associate dean or director of an institute or whatever else that is the way of getting experience. But I think the deans do a tremendously important job. I'm happy I can free ride off of the work of good people. But I would hate to be that for a variety of reasons, one of which is that you can't just do what you think is right in some academic sense. You've got to look out for the interests of the institution and the interests of its employees, the interests of its students for a university, its clients for a law firm. These are very difficult decisions that I won't presume to tell to tell firms how to deal with in situations where it's quite clear they're facing very, very serious possible financial risks and professional risks. Plus, also, there may be some partners at the firm who say to the managing partner, we just want to sit all of this nonsense out. Maybe we weren't terribly wild about some of this ideologically based pro bono representation you folks did. We think that the firm may have gone too far to the left. And if this means that we're going to return more to just representing clients in the particular litigation they have and the deals that they have, and cut down on our kind of politicized sorts of representation, maybe not totally eliminated, but cut down or even provide more of a balanced portfolio of representation, we like that. I don't know if this was true at various lawyers at various firms, but I could certainly imagine there being people who say, look, I'm your partner. I'm telling you as one of your partners that this isn't just in my financial interest, but this is also something that I think is the right path going forward for our firm as a matter of kind of professional responsibility, not in the legal rules sense, but in the sense of the kind of way I want to practice law. So the firms have to juggle the kind of institutional preferences of their employees. They have to juggle the ideological preferences of the employees, have to juggle the economic concerns of the employees, and also have to worry about not just losing clients, but doing right by their clients. They may feel there's some obligation not to paint a target on their clients back indirectly. I can't really speak to who's right and who's wrong as to the decisions they make. I do think that if they challenge these claims, I think in considerable measure, at least as the Section 3, Section 5 contracting government buildings sections, they ought to prevail. So this having been said, I do want to mention something that I've heard from some people. In fact, when I blogged about this on my blog, I got a response, actually a very thoughtful response, I think, from a reader who said essentially, look, here today, big law firms are being attacked. But back when there were lawyers representing Trump in the 2016 and especially in 2020, the various election challenges, they were attacked too. So, for example, there were congressmen who called for disciplinary boards, state bar boards, to have lawyers disbarred. Not just
Oh
have
yeah, I remember
contracts
that.
canceled them, but actually have them legally prohibited from practicing law because they'd represented President Trump, and the congressman said, well, this is they're wrong and they're trying to overturn the election. They were just saying we were trying to make legal arguments about why the election results as reported were actually incorrect. So I think that is a serious an important question. And I offered on my blog a tentative and partial answer to it that I wanted to sort of pass along as well, because it also ties into some of the things that Jane mentioned. So in some of the executive orders, President Trump not only says, oh, these firms essentially took particular litigation positions that I don't like, but also claimed that they had violated various ethical rules here or there in various ways. I don't want to get into all the details, but made sort of factual allegations that the firms violated the rules. And in fact, there are important rules that constrain lawyers in how they litigate. So, for example, they aren't allowed to help their clients commit crimes. Some people might be shocked by that. Well, lawyers are allowed, and in fact, sometimes required to help their clients evade responsibility or perhaps avoid responsibility for committing those crimes, but they can't upfront actually assist in the commission of the crime. They aren't allowed to make factual misrepresentation to courts. They aren't allowed to make legally frivolous arguments, though I think it's rare to be disbarred just because you've made a legally frivolous argument. Usually that leads to financial sanctions. And the existence of these disciplinary rules sometimes leads to demands that lawyers be punished for behavior that, viewed objectively, is perfectly legitimate. People might use that call for bar discipline as essentially a weapon in trying to deter people from doing something. If you represent these clients, if you litigate against me, I'm going to complain. Usually, the people who complain are just adversaries who are unhappy with the way that the opposing side's lawyer behaved and claim, oh, this person suborned perjury or lied or whatever else. Very often there's nothing to it, but sometimes there's something to it. And in any case, the process is the punishment. So sometimes even if the lawyer is vindicated after spending a lot of time and effort and money. So there's no doubt that this does indeed happen, sometimes justifiably, sometimes not, to lawyers. But I think what's really important is that the way our system works is by leaving those questions about whether the lawyer violated specific rules to courts and to bar bodies that ultimately, bar disciplinary boards that ultimately are answerable to the courts. Not to some government official who says, well, I think you were unethical in your litigation against me, so I'm going to order that my government, the government that I'm running, stop doing business with you. Among other things, that's especially true because no person should be judged in his own case. Right? So what President Trump is upset about is the way that these firms had litigated against him. And human nature being what it is, even apart from what you think about President Trump more generally, any human would be a very biased judge of how his opponents have treated him. But even setting that aside, even if it was about some supposed misconduct in some other context, that's something that should be decided by the established judicial bodies that resolve questions about about whether some rules were violated, and not by an executive official who may often have a lot of political gripes with the lawyers involved. So that's what I think is the difference. I think some of the calls for disbarring lawyers or disciplining lawyers or whatever for their litigation positions in, say, the 2020 election were probably unjustified. Some might have been justified. I don't know. I haven't read the records in all of those cases. A lot of those calls did not lead to cases, but at least that was the right, within our system, the right mechanism for dealing with supposed litigation misconduct by lawyers and firms. And what the executive orders are doing is most definitely not consistent with that mechanism. So first, when it comes to the administration's objections to just the kinds of cases the firms litigate, that's a First Amendment problem, although we may not fully agree with that. I think also a Fifth and Sixth Amendment problem in terms of interfering with the right to counsel of those clients and future clients.
Yes.
But even if the claim is, well, it's not just the causes that they litigated, but the way they litigated them, and it was unethical the way they litigated them because it violated certain rules, that's not something that the president should just sort of be deciding based on his judgment about whether those rules were violated.
Okay, makes sense.
A lot more to say about this. We've already said a lot. I'm sure there's a lot more to say. And certainly lots of people, including people wearing black robes, are going to be saying a lot more about this. So Jane, always a great pleasure.
Yes, same to you. Looking forward to seeing you in a couple of weeks.
Absolutely. See you then.
This podcast is a production of the Hoover Institution, where we advance ideas that define a free society and improve the human condition. For more information about our work, or to listen to more of our podcasts, or watch our videos, please visit hoover.org.